Here's a great question from Teddy Halili, our subscriber on YouTube. The question is, to what extent ownership of a registered trademark provides a defense to a claim for passing off? That's a great question, and I'll go in detail to explain what this actually means, what the repercussions are. But before I do that, my name is Andrei Mincov. I've done hundreds of videos just like this one, and I'm planning to do many more. So if you have an interest in learning more about trademarks, about intellectual property, about branding, about what makes a brand great, about entrepreneurship, make sure you subscribe, get notified whenever the next video goes live. If you got a question for me, that's really how I generate ideas for videos like this one. Make sure you post a comment below and I'll try to answer your question. Now, to Teddy's question, well, to what extent does ownership of a registered trademark provide a defense to a claim for passing off? You'll find out in just a moment. All right, first of all, what is a claim for passing off? Now, before there were laws, statutes about trademarks in common law countries like US, like UK, Canada, there were common law rules. There were common law rules for passing off that would allow owners of brands that you couldn't register as trademarks because there were no trademarks back then, to still stop their direct competitors from stealing their brand and taking a free ride on the reputation of a good name. So those were called passing off, and the idea behind those laws was that you couldn't take your product and pass it off as the product of somebody else. But you couldn't just slap a logo of your competitor and say, hey, buy this product, so that everyone would think it's that famous brand's behind it, whereas it wasn't. So that was called passing off. And then they introduced statutory protection for trademarks, right? The Trademark Act in Canada, the Langham Act in the US. But the idea was that in addition to common law protection for unregistered trademarks, there was now a possibility to register your trademark and secure your brand through registration. And so when you register a trademark, your trademark certificate provides you with the presumption of ownership and validity. It's a rebuttable presumption. So here's what this means. It means that unless somebody can prove otherwise, the owner of a registered trademark is deemed to be the owner of a valid mark, right? So the two presumptions. The first presumption is that the mark is a valid trademark unless, again, somebody can successfully rebut that presumption. And also, the second presumption is that the person whose name appears on the certificate of registration is the rightful owner of that valid trademark. Now, if there is a case of passing off against the owner of a registered trademark, it starts the same way as any other claim in passing off. The owner of the unregistered brand first needs to show that they've got a brand. That's the hardest part about unregistered trademarks, because in common law countries, yes, you can do something with unregistered trademarks. It's just freaking difficult and super expensive. So first thing they need to do is establish that they've got a brand. That requires surveys, that requires expert evidence, that requires documents. You just have to show to the court that your brand is known to a significant number of people for specific type of products or services that come from you. So assuming you've established that, that's the first thing you need to establish with a claim of passing off. The second thing you need to establish is that the defendant, the person or the company you're suing, is offering similar products and services to yours under a similar brand in the same geographical area where your brand is known, and they do it without your permission. So if you can show all of that, then that beats the presumption that the defendant would have with the trademark registration, as long as you have a prior right, and as long as their trademark is not an incontestable trademark, and as long as they didn't register their trademark through fraud, and as long as they didn't register their trademark knowing about you. So there's a million things here. The problem with that is proving all of that requires a lot of resources. So if you are a owner of a registered trademark, is it a 100% guarantee that there is no other firm out there that could sue you for passing off? No, but the risk of that is minimal, because the idea is very simple. If they didn't bother to trademark their brand when it was easy and inexpensive, the risk of them finding $50,000, $70,000, $100,000 to go after you with their unregistered trademark with a claim for passing off is almost non-existent. So could they do it? Maybe, but very, 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 very unlikely. So that's why you got this whole idea of rebuttable presumption, right? That unless that presumption is rebutted by evidence, by arguments that the court agrees with, that presumption stands. But it's not ironclad. It could be rebutted if they prove otherwise. So that's how it works. So if you got a registered trademark, unless somebody goes after you and cancels that trademark because they can prove to the judge that the trademark was registered improperly, you're the owner. You're the owner. Even if everyone understands that this trademark should not have been registered, until that's actually formalized in a decision, the owner of a trademark is the owner of a trademark. So I hope this answers your question, and make sure you like this video. Make sure you post a comment below if you have additional feedback, or if you have a question for me that you want me to answer. And we'll just go from there, right? And until then, I'll see you in the next video. In the next video, I will see you, of sure.